Good afternoon, everyone, and thanks for joining us. My name is Daniel Zand, and I'm an articling student at DeRusha Law Firm, and I'll be the moderator of the session. The speakers today are Golan Yaran and Syed Kabir. They are lawyers here at DeRusha Law Firm with more than 20 years of experience, and they both have experience practicing law in multiple jurisdictions. They are first going to cover a variety of topics. Once they are finished with the topics, we will then proceed to answer any questions that you may have. If you have any questions, please make sure you write them in the chat. The chat option is available on your screen. You can type your questions there and send them to me, and I'll present them to our speakers. Please note that this is a general information session and nothing mentioned should be taken as legal advice. Golan, can you start us off with our first topic, which is what happens to property of spouses when one passes away?
Yes, certainly. Firstly, good afternoon, everyone, for those who are attending this session. Much appreciated. As to the topic of when one passes away and what happens to the property, normally it's kind of an intersection between estate law and family law. But the family law does provide for that situation that a spouse have the option of electing. And what I mean by that is that the family law provides for the right for equalization if the partners were married. And then if the spouse who passes away did not leave or did leave a will behind, then the surviving spouse have the option of either taking according to that will or according to his or her entitlement, as if the parties were divorced or separated the day before that person died. In that sense, the normal situation would be that one would have to assess their situation and decide whether they wish to proceed based on what was left to them in the will, or whether they should do their calculation as if they were separated the day before, and then you get to do the calculation as we will later on expand on, and we'll talk about that as well. But the idea is that the surviving spouse have an option. Anything to add, Syed? Take it away.
First of all, thank you everyone for joining us today. This is our third webinar session. And in terms of the topic that we are discussing now, so in terms of the election that Golan was mentioning, so there is a deadline actually. So within 6 months of the passing away of the spouse, the other spouse has to actually inform the registrar of the state's court as to whether he or she wants to go in terms of the will that the person who died made, or wants to go by way of the family law equalization calculation, about which we are going to talk later on. The other thing that just I wanted to add is that if there is no will and if the parties were common law partners under the laws of Ontario as well as Canada, the other spouse would not be entitled to equalization, and this is something that we're going to talk about later on as well. So those are the two things that I wanted to mention. Daniel?
Syed, can you talk about our next topic, which is property division? And if you can talk about the laws and rules in regards to married couples and those that are living together in a common law relationship?
Yes, of course. Thank you, Daniel. So in terms of property division, it depends on whether the parties are married or common law. If the parties are married, then the laws actually have state that the right of equalization actually arises. So basically, there is a calculation that needs to be done, and we also calculate what is called the net family property. And these are based on the family law rules, Family Law Act, as well as the Divorce Act for married people. And then we calculate as lawyers in terms of the assets and debts on the date of marriage and the date of separation. And then we calculate how much each spouse would pay to the other spouse in terms of married people. In terms of common law partners, it is not the same. The common law spouses in Ontario do not have any right to the other spouse's property under the law as such by way of equalization. However, there are some concepts of trusts and equity, which Golan will speak about later on. And through that, actually, a claim can be made by a common law spouse on another person's property. So the difference is if the parties are married, then there is a right of equalization. But if it is common law, the law does not give a right in Ontario of equalization to that spouse. Golan, you want to add something to that?
No, as you indicated, we're going to look into the common law situation and how one can or may have an interest in the other's property in a situation like that. The idea is to differentiate between these two a legal type of relationship. The court have mentioned that parties that decide not to have a legal marriage decided basically made their own informed decision as to how they wish to manage their relationship, and therefore that differentiation of the property division exists. However, they did find ways to make things more just and fair when it comes to especially long-term common law relationship. We'll speak about this more as this session goes further.
Golan,
Tanya?
the next topic we have is common law partners and potential interest in property, such as a joint venture.
Okay, so that's basically the follow up from the previous topic, and that is where does the common law partner may make a claim for somebody else's or the partner's property uh, because of the nature of the relationship that was going on over the years. The idea is that, in all fairness, when people live together and they start, they may be investing together, they may be helping each other out, such that one may have a career and the other will raise the children, and in all sorts of ways there could be a situation where one partner is being given or investing time, efforts, or money in terms of making the property increase in value and so forth. So, for example, uh, assume that one has a house in one's name and only one party is paying for the mortgage and the other party is in fact doing all the renovation and investing money in putting a new kitchen in, etc. That becomes a situation where both parties will have an interest, very likely, in that property, and they would be able to claim that even if the title to that property is only in one's name. That's the reason that we have the concept of joint venture, that's a joint family venture. Other concepts of trust are more complex, such as resulting trust and constructive trust, which is more common in a situation of common law relationship. That every situation is very specific and very fact driven in order to come to that conclusion of trust or a interest in one's property when there's no legal ownership. Find anything else to add there?
Yes, so thank you, Golan. So in terms of that type of relationship, I would also like to add that there can be a situation where parties are living in common law and maybe they're in a situation where they cannot qualify for a mortgage. And sometimes I have seen situations or cases where both of them cannot qualify for a mortgage, and then they take the property in the name of a parent or an uncle or somebody senior who has more income and who can qualify. So in that situation also, if these people who are common law partners have invested in a property by mortgage, by renovation or maintenance, and then they can show that, and they have actually thought that property to be theirs. And of course, in this type of relationships, the other thing that plays a very good role or an important role is a declaration of trust. So if there's a document which says that, such other person is holding the property in trust for these common law partners, then that also, can give rise to a claim of constructive trust or resulting trust, as Golan was mentioning. So these are situations that we always are very commonly see in common law relationships, where either of them is holding a property in trust for other, or the both of them have invested in a property, but it was in the name of the other. And the courts have granted reliefs where the court have seen that these people have invested money in those properties. And, it has to relate to somehow the title to the property, basically meaning that, it can be mortgage, it can be property tax, it can be property insurance, or maintenance of the property. Utilities and bills will not be considered as such, because any tenant would also pay utilities and bills. So yeah, so these are the situations that we commonly see in our practice.
And Syed, can you talk to us now about equalization calculations and how this is usually done?
Of course, Daniel. So yeah, so in terms of the calculation of equalization, the way it works is on the date of marriage. If it is, first of all, equalization calculation only applies to married people. It does not apply to common law, as I stated earlier, and Golan also mentioned that. So in terms of the calculation, the way it works is on the date of marriage, there is a value, right? So basically that means that people have assets, people have debts, but the asset cannot be in a negative number. Even if they have negative, debts or whatever, the law basically says that the calculation, for calculation purposes, it will be zero. So we calculate, or the law says that we have to calculate the asset minus the debt on the date of marriage. And on the date of separation as well, we calculate the asset minus debt. So if we deduct the date of marriage from the date of separation, then we call something which is called the net family property is arrived at, and that is calculated for the husband or the wife. And then we also do the same calculation in terms of the husband or the wife as to his or her net family property value, meaning the date of marriage value, which is the asset minus debt on the date of marriage, has to be deducted from the date of separation value, basically the asset minus debt on the date of separation. And then we get another net family property value. The law basically says, suppose the husband has $100 and the wife has $50 in terms of the net family property. The difference is $50. So the law says the husband has to pay the wife 50%. So basically $25 to the wife. Now, in terms of calculation of the net family property value, or the for equalization purposes, what we prepare is a financial statement for people. And there is a specific form given by the Ontario courts, which is called the form 13.1, which relates to properties. And that is basically states, what are the assets, what are the debts, and there are some exclusions as well. So these can be proceeds from insurance claims. This can be inheritance from a person, and also any property that a person had on the date of marriage can also be excluded. However, there has to be a clear tracing of that property, as well as, to show that, how much that person had on that date of marriage. So there are these calculations that needs to be done. And then we arrived at the equalization, which I stated, the difference between the two net family property values, and half of that amount is usually paid to the other person. Golan, you want to add something to that?
Perhaps only to simplify for the listeners, the scheme of equalization is practically sharing of the family wealth that was accumulated from the date of marriage to the date of separation. The separation date, not necessarily the divorce date. So it would be the date of separation, and that also has its specific rules as to when a separation date is intended and determined. But the idea is that the parties will get to take out what they came into the marriage with, and they get to share in what the family together have accumulated and have increased their assets over the years. And as Syed mentioned, there is very specific methods of the calculation, applying various exemptions, and all of this need to be very carefully recorded and calculated in order to arrive at the right amount that one may owe to the other. And as Syed said, at the end of the day, we're not starting with a negative of a net family property, but rather it's starting from zero, or it may be higher than that. So even if one party only has debts at the date of separation, his net family property would be considered as zero. There's a lot of very specific rules, and it requires very detailed attention. But in general, the idea is to share the accumulation of assets.
Golan, I just wanted to add there in terms of the limitation period, because a lot of people are not aware of that. So if there is a claim for equalization, if parties are separated, they must resolve it within 6 years or make a claim within 6 years from the date of separation. And if the parties are divorced, which can only happen by way of a court order in Ontario, then you have 2 years from the date of divorce. So if you have a right, or if any party has a right to equalization, they should not wait for so long that then the claim will fail after 6 years or 2 years after divorce.
Golan, our next topic is keeping records of value of property and date of marriage and domestic contracts before and during marriage.
Yeah, so this is one of the important topics that we try to educate clients and the general public whenever they go into that decision to enter into a relationship of permanence, whether it's common law or whether it's going into marriage. Things could be getting very straightforward if people come into the relationship with the expectation and understanding of what's going to happen. And I apologize for that. For some reason, I'm getting a call here. But what I mean by that is that when people are entering into the relationship, they have the option of entering into an agreement first of all. The idea is that some people call it before the marriage. It's being called the prenuptial agreement, and it is possible to also enter into that agreement during the course of the relationship. People can record their assets when they come into the marriage. They can decide on exclusion of any of the assets from equalization if and when a situation arises that they require to equalize. The other topics that may be covered is specific homes, cottages, investments, inheritances, whatever comes to mind in terms of what happens if we were to be separated and we had to split the assets, what will happen. And we can exclude a situation such as the matrimonial home, especially if one comes into the marriage with a home prior to the parties becoming a common law partners or married couple, because the matrimonial home specifically has the effect of not being exempt from division if there is no such a cohabitation or a marriage contract in place. So there is a lot that can be covered in a domestic contract. There is rules and regulations that have to apply, including a full disclosure and the ability to obtain independent legal advice. And obviously, we recommend that these type of things will be done well before the intended marriage date, so it's not looking like there is a guns to one hand just before marriage, and then the argument is whether one was compelled to sign or else the whole thing falls apart just before marriage. So there are things that has to happen in the event of even the thinking of getting married or getting into a long-term relationship with another partner. Said, anything else?
Yeah, so just to add to what Golan was saying, two things. One is it is very important to understand that when parties enter into a domestic contract, which can be a cohabitation agreement before the marriage, or prenup agreement, which is actually in the United States, they call it prenup. And also during the marriage, there can be a marriage contract. But one of the important things is financial disclosure, basically meaning that both parties have to have give the other party a full and frank and financial about the financial information of the other side. Because we have seen a number of cases where parties agreements are challenged later on, and when there is lack of disclosure and there is non-disclosure or misdisclosure, then these agreements are set aside by a court of law. So it is very important to actually have the records right, so that they have the information as to the amounts in the bank accounts, the value of assets, and all those things, so that there is no question that there was any issue with respect to the financial information that was exchanged. The other aspect that I will just put emphasis on, as Golan was also mentioning, is the independent legal advice. So I have seen situations where people who have, who thought that, okay, we can just download it from the internet, a precedent agreement, and we can sign it amongst ourselves. I have seen so many times that, these type of agreements, even, educated people and people in, higher positions in the corporate have done those type of agreements between themselves, and that has been set aside by a court of law, primarily because there has been no independent legal advice, which basically meaning that the other party can say that, I was signing this agreement, but at the time of signing the agreement, I did not know what I was signing. I did not have any lawyer explaining to me what I was signing. So that is very important that along with that agreement, there has to be a certificate from a lawyer, which is called a certificate of independent legal advice, meaning that that lawyer will actually explain to that party each and every provision and what they're entering into, so that later on, either party cannot go back and say that, I did not understand this agreement. So these are the two important things that I always found about domestic contracts.
Syed, can you talk to us now about ways that one can resolve property issues, whether it's through court and trial or whether it's mediation or arbitration?
Yes, thank you, Daniel. So in terms of resolving any property-related issues, you have three options basically. Actually there are four options. One is, the parties can negotiate themselves and come to a settlement, and then they go to their lawyers, and the lawyers draft the agreement and negotiate between themselves, and then come to an agreement. That is, of course, what we call negotiation in law. The other option is mediation, where the parties can go to a mediator. So the mediator can be a lawyer, and it is preferable that if it is property-related issues, the mediator, we always suggest that it should be a lawyer, because the lawyers have that type of experience in dealing with property-related issues. And then mediator actually listens to the parties and facilitates an agreement between the two of them. And subsequently, they can prepare an agreement. However, it will be for the parties to decide whether they want to go to a lawyer and seek legal advice, and then they sign it with their witnesses or with their lawyers as they deem fit. The other option, which is of course the least desired and most expensive option, is litigation. So we never suggest people to go to a court, because as you all are aware, the court process is very expensive. You have to pay the lawyers. Even if you are self-represented, it would be very difficult for you, because you don't know how the process works. There are so many forms to fill up. So, and especially if there's property related issues, as we discussed before, there is this calculations of, financial statements, and, what goes in, what doesn't go in, what are the exclusions. These are all things that a professional can advise you. And we have done it, and we do it on a regular basis with our clients. So in terms of all the options, I would definitely suggest that, mediation is the best option. However, it needs to be understood that mediation is not an option in all cases, because before we do any mediation, we do a screening. We have to understand that, the parties are voluntarily agreeing to mediation, as well as this is an issue that can be mediated. So once we consider that everything has been done, and we consider that this is a suitable case for mediation, then we only proceed for mediation, and then we have resolved issues through mediation, which is the least expensive option. So Yeah, so these are the options. And of course, sometimes there is mediation arbitration where people decide that, okay, if we will try to mediate first, and if mediation fails, then we will do arbitration, but with the same person. So that is another form of dispute resolution process. So these are the different steps. Golan, you want to add something to that?
Maybe just to clarify, so the audience understand that the idea of independent legal advice is absolutely desired and recommended, but it's not a must. So obviously, parties are able to decide that they do not wish to have independent legal advice, with the understanding that they cannot come back later on and argue that they did not have that opportunity. Uh, that's the reason that we definitely recommend and urge parties to always seek independent legal advice, whether it's when using us as mediators or using us as their own lawyers in the proceedings on negotiation. Um, in terms of, I think mostly the options were covered by Syed. We obviously recommend the least expensive and the more amicable option of mediation, when parties can actually feel more comfortable. They can do it with their lawyers or on their own, depending on their on their situation. It could be with the parties together. It could be with the parties apart if they're not comfortable with one another. So the options are there to accommodate a variety of situations that are much less intimidating than going to court and being in a public courtroom with respect to the proceedings. That's what I wanted to add to this topic.
Yes, Golan, you're 100% right. So basically, just to add, so the way I define it to my clients when I do mediation is that mediation is a custom-built solution. So you are the ones who decide, and then you decide how you want to do it, right? But in a court of law, the judge applies the law. So the judge will, even if you say something else, but the judge, unless there is of course a consent between the parties, the judge will apply the law. And sometimes I have seen that the court order is something that neither of the parties desired. So in a mediation setup, the parties, as Golan was saying, can be in a very informal environment and can discuss, and they understand the situation better and come to a custom-built solution.
Thank you guys for that. We're now going to answer any questions that you have. I want to thank those of you who have already sent us your questions. If you have not sent us any of your questions, it's not too late. You can use the chat option on your screen and type in and send me any questions that you have. The first question that we received is, we got together and started living 5 years ago. We are in our 60s and we both have children from our previous marriages. We keep our finances separate. If we separate, would she have a claim on my house that I have owned for many years?
I can answer that question, Daniel. I'm just going to look at it in general terms. My understanding is that we're talking about a common law type situation. They have not mentioned that they were married. They were just saying that they were living together for 5 years. The idea, again, we spoke about the right to equalization and the right that the common law partner may make on a property that belongs to the other. So this situation can arise, even in these specific situations, we have to look at more specific set of circumstances to be able to give advice to that party. And that has to do with what contribution that party was making to the house, whether it was by way of mortgage, whether it was by way of domestic services, maybe renovating the home and causing it to go up in value. It could be many things that may arise as a result of this relationship. Normally speaking, generally 5 years is not a significant period of time to establish an interest, but the situation could arise depending on the specific facts of this relationship and what happened and transpired as between the two parties in terms of the give and take and the exchange. The matrimonial home, as it by itself, has a specific a status in the parties' relationship. So it's still a matrimonial home of both of these people, even if only one party is registered on title to it. So there are rights that flow as a result of it being a matrimonial home in terms of occupation, but not necessarily a for the division or a claim regarding the equity in that property. So again, it's very fact specific driven, and we need to really analyze the situation in a better fashion. Any other comments, Saad?
No, I think you covered it very well, Golan. As you stated previously, when you were discussing the common law relationship and the claim of resulting trust or constructive trust, that basically plays a role here, depending on the circumstances, that if the other partner has actually contributed, and then in that case, there can be a potential claim of a constructive trust or resulting trust. And of course, if they are married, then the claim of equalization will arise. So you have covered it all.
The next question we have is, my wife and I have been married over 20 years. Our children are both going to university and it is very expensive, and therefore we still have a large mortgage on our house. Within the last 2 years, my parents have died and I'm now inheriting over $500,000. I think it would be best to pay off the mortgage of my house. My estate lawyer said that I should keep the money separate. Can I pay off the mortgage of the house?
Okay, and Golan, if you allow me, I can answer that. So basically, thank you for the question. This is a situation where the parties are married, and the question of equalization will arise if the parties ever separate. Now, instead of going to the specific, fact-specific situation here, I would just say that the question here is about exclusion. So inheritance money can be excluded. However, it has to be traceable on the date of separation. So that is very important. So if you have, or if a person has inherited money, then it is important to show that how the money came about, whether it was through a bank account or through another person. That's one important thing. The other important thing also is to show that the money is still there on the date of a separation. So if the money is actually mingled with other properties with the spouse, then there might not be, it would not be possible actually to claim that okay, that money should be separated because that was an inheritance property. So that is probably why the state lawyer is actually advising that the money should be kept separate. Now, in terms of paying off mortgage, now of course that is something that you have to decide. But again, if that person actually decides to pay off the mortgage, maybe an agreement needs to be signed off between the two of them, which can be a domestic contract whereby the other party would acknowledge that this amount was a separate excluded money which comes from inheritance, and that is being invested in that property to pay off the mortgage. And then later on, if there is any separation, then that can be taken into account as an exclusion. So there are ways to do this. So I believe that we need more information about the situation, and by way of a consultation and by discussion, then we can suggest what would be the best ideal solution or resolution in this case for the questioner. Golan, do you want to add something to that?
Perhaps just the form of the question sounds like that person's lawyer is already suspicious, or at least thinking ahead that these parties may be separated or divorced any time in the future. So that kind of the immediate advice that he was given to keep the inheritance money separate. But like Syed said, I think that without assuming that, the ideal situation would be to have um, an agreement in place, something that would be considered as a domestic contract that would spell out the intention and the fact of the inheritance and how it's being used, and its exclusion if and when if that becomes an issue. But if one would be thinking about a separation and knowing that he's getting the inheritance, uh, if you wish to have that excluded, then obviously the recording and the tracing becomes an integral part of the whole process.
The
Daniel,
next,
take it away.
yeah, I'm here. The next question I have here is that the person I've been living with and I wanted to get married this year, but because of the virus, we have postponed it till next year. She works as a waitress, and I have been a crane operator since I was 21, and I have over 25 years of pension. Is it correct that if we get married, she will have a claim on my pension?
Golan, you want to answer that?
Yeah, I can answer that. It really was covered in the topics when we spoke about the rules and what applies to common law partners versus married couples. In this situation, the parties seem to be intending to marry sooner or later. I guess the COVID-19 only postponed their plans. But the idea of once sharing in the other's property in terms of equalization will arise upon the parties being married. Uh, but whether, but if we speak about the pension or whether it's another asset that a person came into the marriage with, this is one of the things that when Syed was speaking about the calculation of equalization, it's being taken into account in terms of what was the value of the asset at the time of the marriage. And the sharing is really in the increase in value of that asset. So the parties will be together for the next 25 years, then it's not the first 25 years of the pension that's being divided, but rather the accumulative portion of the next 25 years between the marriage and the separation. I think that covers that topic, unless Syed has anything else to add.
No, I think you have covered it, Golan. And basically, in terms of valuation of the pension, we have the Financial Services Commission of Ontario, who actually values pension, and yeah, so only the increase in value if the parties get married would be considered in the calculation of equalization if the parties were to separate later on. Yeah, so you covered it, Golan.
The next question we have is, my partner is a drunk and is abusive to me, and he spends no time with the children. Can I have that person thrown out of the house?
Okay, and Daniel, if I can answer that. First of all, when people come to us and the clients come to us and say that, okay, there is a situation where there is abuse, we get worried, and of course we should be worried, because safety and security of that individual and the children is the first and foremost thing that we have to consider before going into calculation of properties and equalization or whatever the law states in terms of property related matters. So in this type of situation, I would suggest that the person first has to seek some sort of assistance from there are so many victim services. There can be the police who can assist, or there can be so many other services that are free of charge. So that is of utmost importance, because I don't know what when you say abusive to me, or when the questioner said abusive to me, to what extent it is it physical or it is verbal. The other thing that that can be considered is if he's drunk and if he has an alcohol related issue, the person can be suggested to go for counseling, or there are so many options available where they can try to get cured in terms of the alcoholism or the addiction that they're having. In terms of the property, this is actually a mixed question, because as I said before, that when you talk about abuse and drunk, it can be part of criminal law, but we are now dealing with family law, so I'm not going to go to that area of law. But in terms of family law, a lot of things would depend on who is the owner. However, the person would have a right to go to court and seek a refraining order or a restraining order, so that the other person cannot actually come within the house or within a certain parameter of the house. The criminal law also deals with it in a separate manner. So those are options open, but again, we would not suggest the questioner to actually ask the other person to leave if he is drunk or he's abusive, because that can result to other, unfortunate incidents. So this is something that we have to be dealing with very carefully, and I believe that we need more information before we can provide any sort of legal information or legal advice, and then only we can discuss the steps that can be taken by that individual. Golan, you want to add anything to that?
Well, the only thing that I think people have to understand is that from our perspective as lawyers, yes, safety is a first concern. And we would even suggest to that person to seek shelter if need be for him or her and the children if that person feels threatened in any way. I would rather, as a lawyer, first of all, our mandate is to suggest that we'll resolve things through the civil proceedings, and restraining order may be the more appropriate things to pursue if that person feels threatened or it needs to be kept away from the other spouse. So a restraining order is definitely a way to go, and a application to the court can be done in various ways. The restraining order is normally being updated with the criminal information system, such that the police is being informed of it, and that's how the court order is actually being followed or monitored in such a way that would give effect to that restraining order and the concern of that client that wants to keep safe and be away from the other spouse.
The next question I have here is that I've been working for my father's company for a number of years, and he says that he is going to give me the company. He's going to give me the company if my fiance agrees that the company is all mine. And the question is that how can I get her to agree, as my dad wants this in writing?
Golan, you want to answer that?
Yeah, if I can answer that, I think that was also covered in my a general discussion regarding the domestic contract, and that situation falls into that a prearrangement that can be made prior to people getting together in in a marriage into a marriage relationship. So it could be that one's parents or another partner wants to be protected in the event that his partner is going to be married and now may have a claim or have a stake in the corporation. Um, those situations can also be covered in the domestic contract, in the marriage contract or the cohabitation agreement, to ensure that that specific asset is going to be passed on to only that person, or to limit the involvement of the other partner in any decision making or anything of that matter that relates to the corporation. So if a party wants to maintain control, let's say that in this case was the father and he has maybe have other siblings, or just want to leave everything to that one person, then the protection can be part of a domestic contract, and the party to the domestic contract is in fact the corporation as well. So they all become parties to this agreement on what happens to the corporation if and when there is a transfer of the shares from one to the other. And again, that requires definitely a detailed review of the shareholder agreement and the specific of the corporation and the intention as to how things going to be dealt with in due course.
Yes, so Golan, just to add to what you're saying is, from the question, I understand probably they are thinking of getting married because the questioner said, my fiance, that's what I heard. So if that is the case, then as we stated before, that it is very important to have the proper value of the corporation, so that the fiancé doesn't say later on, if an agreement is signed, that, you know, I didn't understand the value of that property and I signed it without understanding all the financial information. So that is important. And as we discussed before, we always recommend that if possible, and you know, they should seek independent legal advice, so that, you know, there is no question of not understanding the agreement later on. Yeah.
And the last question we have, guys, is that my husband has developed a gambling habit. He has been spending a lot of money and cashing in his RRSPs. What can I do to protect myself?
Okay, so
Would you
Golan, if
take
I
that,
can
Zan?
answer that. Yeah, okay, thank you, Golan. So this is a difficult situation that you're in, and I'm sorry that you're in this situation. The only thing is that, you know, uh, when you have this type of situation, and when you say that, you know, what can I do to protect myself? So the question, when you say what can I do to protect myself, is this protecting you from your husband, or is it protecting the financial interest? That is something that we need to ascertain first. In terms of protecting yourself, if he's gambling, and I don't know whether with gambling whether there are any other issues that he's involved in, being drunk or anything like that, and if there is any abuse related issues, then as we discussed before, it is important to ensure that, you know, you are safe and secure. And if there's children involved, then that is something that we, of course, you know, have to discuss. And then, you know, you have to think about it going forward, so that, you know, there is no unfortunate incident. Now, in terms of the money that your husband is investing, or basically spending, when you say a lot of money, first of all, is it from the joint accounts? Is it from his own account? That is a question that needs to be ascertained. If it is a joint account, then one of the things that you might consider is having an individual separate account, so that he cannot deplete your portion of the money. That's one thing. In terms of cashing his RRSPs, so one of the things that needs to be considered is that, you know, when he has RRSPs, whether there is any contribution from you towards those RRSPs. So if that is the case, then you might talk to him and think about, you know what, you are spending money recklessly, and, you know, you're gambling, you're wasting it. So we might want to do a separation, you know, a cohabitation agreement, or you guys are married. So basically, in terms of that, it will be a marriage contract. So that is something that that you can think of doing to protect your interest in the financials. And as well as in terms of the other thing that you can do is you can talk to him and say that, you know, if there is any possibility of, you know, suggesting him to go to counseling, and so that, you know, he can you know, get away from this type of, you know, gambling habits. So those are the options actually. But at the end of the day, in terms of equalization calculation, if you were to separate, and if either party or if a party alleges that the other party was gambling or recklessly depleting assets, then a person can claim unequal division. The burden is quite high, because the courts are not, you know, I mean, they usually do not like randomly, you know, give this unequal division type of, you know, order, but they have to make sure that the person who has been alleged to deplete assets has been doing it recklessly and intentionally. And the other thing is, if that is something, you know, if you were to transfer any property in thinking that, you know, there would be a separation, courts also have authority under different laws, which basically allows to set aside any transactions related to transfer of property. So there are various options that is available to you, but you probably need a consultation, and we need to know more information from you, so that, you know, we can review the entire situation and then suggest what is the best possible way forward. Golan, you want to add something to that?
I think you covered most of it. So I think we're probably running out of time there. Daniel, do we have anything else? Or
That was actually the last question that we had. So I want to thank everyone I want to thank you for those who have submitted your questions. If there are any more questions or concerns that you have, a consultation can be arranged to evaluate your specific situation or circumstances. As you can see, the contact information is on the screen. You can send me an email, give us a call. You can also visit our website for more information. As I mentioned earlier, this was a general information session. Nothing mentioned should be taken as legal advice. That concludes today's session. I want to thank Golan and Syed, and I want to thank everyone for attending, and I hope you're able to join us next time.
Thank you, guys, and thank you for those who attended this session.
Yeah, I want to thank everyone, especially Daniel, for being an excellent host. Thank you, Daniel.
Thank you.